Super fun.
Hi, everybody. Thanks for joining us. There's lots of people coming in, but we'll just get started because we have some people watching online too. So welcome. My name's Angie. I work with New Ventures BC, and this education series is part of the annual New Ventures BC competition presented by Innovate BC. And for those in the who's in the competition right now? Okay, so a fair amount. So yeah, I have no results to share with you. By the end of May, you'll get it. You'll find out by email. So we'll send you emails once the results are. The judging is all underway right now. But in the meantime, we get to learn. So first, the subjects on corporate structure. I'll introduce the three speakers momentarily, but first I'll just say that we are here gathered on the ancestral traditional unceded territory of the Coast peoples, including the Musqueam, Squamish, and Tsleil-Waututh First Nations, and we are privileged to do so. I'd also like to thank our sponsors who make the competitions happen every year. So our lead and title sponsor is Innovate BC, Crown Corporation supporting the Quebec ecosystem. Gold sponsors are EY, Fasken. Thank you for hosting us as always. If you get later on in the competition, you'll come back here a few more times because Fasken is very generous with their space, and National Bank. Silver sponsors include Vantech, SNBD School of Business, Talk Shop Media, UBC Sauder School of Business, and RBCX. And then we have lots of great bronze sponsors who are good parts of the community here in BC. And just to let you know, a few more things upcoming. So I don't think we're doing anything next week, but 2 weeks from now, we have a couple webinars going on. So Nando Within Capital, the SHRED program. So we have some folks from EY who will walk you through the ins and outs of that process. The one thing I take away, having watched that seminar every year for multiple years, is you need to be very organized and know what you need to track in advance. So it's good to know, it's good to attend so you kind of have an idea of what how to do oh, something just happened. Okay, that's fine. Basically, the other slide left was we also have a managing your intellectual property webinar that's happening on May 30th. And that program is that seminar is delivered in partnership with another program we're in called Accelerate IP, and that's to give startups education, mentorship, and money towards service providers for your intellectual property strategy and implementation. So that program is called Accelerate IP, and we'll talk more about IP on that day. So for today, we're going to talk corporate structure. For those that attended our capital financing workshop on Monday, if you didn't, that's okay. We recorded it. You can access it later. But for those who didn't attend, this is a good follow-on to that session because a lot of the things that were talked about on Monday around kind of valuations and cap tables and how you set things up, some of that will be covered, from a different angle today as well, along with other things. So we have three Fasken speakers here. So we have Geoff Pedlow, Samuel Lee, and Hardeep Gill. So, and I think they'll talk you through slightly different aspects of the conversation. So I'm going to switch slides, and I'll let you introduce yourselves while you do that. Thank you.
Yeah, we'll do a quick intro. So I'm Geoff Pedlow, a partner in our emerging tech group. I work with startups, high growth companies from ideation through exit. But first point of contact for all kinds of issues that arise, and a lot of the hands-on work that I do is more in the venture financing and of course the later stage in M&A as well.
Sam Lee, I'm a partner in the securities group. I do more of the public securities type work, but also do a bunch of work with emerging tech companies.
And I'm Hardeep Gill. I'm a partner in our tax group, and I have a pretty general tax practice. Part of it is to advise. Part of it is to advise on startups on a lot of the complicated tax issues that arise early on in the business, as well as helping established startups being in the various tax issues that arise later, and then including a sale if there is a sale. So a lot of my work is transactional tax work.
Thanks. I've got a couple of slides here that are really just sort of self-promotional, but the gist of it is that So we're obviously a large national firm, and we're a full service business law firm. As you heard, we've got specialists in all different areas. Our emerging tech practice in particular, we work with early stage companies, and so we've structured our service offering in a way that's sort of more accommodating and customizable to make it work from a cost perspective as well, and so that we kind of partner with you, grow with you on your journey, and as you grow, we have specialists that can help you with sort of any kind of legal issues that arise. We've got a fair amount to cover today, and I think generally it's worked best that we more or less hold questions until the end, and we'll try to leave a good amount of time for that. Often there are a lot of questions, including questions that often kind of get into the very specific issues. So we'll try to avoid specific questions. We have questions, the more hypothetical they are, the better. The content today is really around kind of legal 101 for startups. It's a pretty broad range of legal topics that are relevant to know about in the early days and as you grow. And hopefully, some of it touches on financing, which I understand you've talked about a little bit in a prior session. But it kind of tries to cover a lot of the relevant map, which is often corporate securities and tax. And in general, we'll talk about corporate structure, how to structure the company, and then also the legal agreements associated with that. How you set up the company with the equity ownership, how do you attract tools for attracting team members using equity, and also kind of employment agreements to some extent. And then also talking about sort of financing considerations. And then as it relates to legal agreements, sort of the foundational legal documents for the company among the founders and others, internal documents that are relevant to sort of set up the business, and then externally some of the legal documents you'll encounter in the early days that you'll enter into with third parties. So I'll start here, and this is kind of an overview, or here's the different options that you can explore in formalizing the legal structure of your business. And a lot of this won't be relevant, but I'm going to explain it anyway. You have a proprietorship, which is just kind of an individual operating a business on their own. It's really the simplest form of a business. A partnership, which is very similar, except that it's more than one person. It's multiple people carrying on a business with a view to profit without a formal sort of incorporated legal structure around it. There's different types of partnerships. You could be a general partnership where each partner is sort of jointly liable for all of the liabilities of the business. And then there's limited partnerships, which are usually only used in the context of a fund structure where limited partners will invest, and you have a general partner that manages the operations. You're not going to incorporate your startup company as a limited partnership 99.9% of the time, or more than that, pretty much 100. And then there's joint ventures, and you might hear about this too. And these are kind of you and another business operating together in a particular area. You're contributing assets or funds or time and money. And there's different ways to structure a joint venture, and sometimes it's its own corporation, or it could be a partnership or just a contractual joint venture. The most relevant one here is the one at the bottom. These are companies. In almost all cases, when you're formalizing the structure of your business, you're going to incorporate a company. At least in Canada, there's a few different. In the US, there's a couple of different variations to what a company structure could look like. But in Canada, you're going to incorporate a company. It's either going to be incorporated provincially in the province that you're in, or you can incorporate federally, and then you register in the province that you're operating in. But this is the structure that most startups go with. It provides limited liability to those that are incorporating it. So that's sort of the key foundation to it. There's share capital, so you can bring on investors, issue shares to others. And it's a separate legal person. And so your company is entering contracts, your company's taking actions, your company's operating the business. It's not you personally. We'll talk about different roles within the company later, but you're an operator within the business, or director, officer, or all of those. It's a separate legal entity, and that's the key part of it, so that you can kind of separate this from your own personal legal status.
So just at a really high level, this is the structure of a company or corporation. Generally speaking, you'll have shareholders at the top who are essentially the owners of the company. And you see one of the shareholders there holds through a holdco of some sort. The box in the middle is really your company, and that would include the directors who are elected by the shareholders. And then the officers who are appointed by the directors to run the company, and then employees who, essentially do the day-to-day. And potentially you could have a external advisory panel of some sort. So shareholders, starting with shareholders, they're generally understood to be the owners of the company. And they become shareholders by buying shares. And a share is essentially gives the holder a bundle of rights. And for the company, when they sell shares, it obviously gives them funds to operate. The shareholder can really be any type of legally recognized person. So it could be other companies, it could be individuals, it could be partnerships and whatnot. Really, it comes down to the characteristic of the investor. And there's no rule on how many shareholders you can have. Generally speaking, the more you have, the more complicated your, dealing with your shareholders will become. And this creates practical problems with this dealing with a larger shareholder base. There are other considerations we will talk about later. There are certain kind of thresholds that are always important, and one is a 50-person threshold that we'll talk about later. So a shareholder means that you have a share means that you have a bundle of rights for the holder. And these rights are typically what we would associate with owning a company. The one main benefit of a company is what Geoff already mentioned, which is limited liability. And you'll see that there essentially a shareholder has no liability other than the money they've invested in the company. So they can't come to you personally, which is different than something like a sole proprietor where, if something goes wrong, they can come after you personally. This would be the case unless, there's some sort of contract that says otherwise, like a shareholder agreement. So the bundle of rights will depend on the rights and restrictions of those shares that you're holding. Typically you'll have something called a common shareholder and potentially some preferred shareholders. And normally common is the more general, and preferred you have some sort of special rights. So the rights can go to voting. You can either have voting shares or non-voting shares. You might want non-voting for employees or passive minority shareholders. And you can actually have super voting rights as well, where certain shareholders get particular approval rights on whatever might be. Dividends, practically speaking, for early stage companies, you're going to not want to pay dividends. You're going to want to keep the money in the company to invest for growth. But with that being said, certain investors might get some sort of preferred ability to get dividends if you were ever to do it. Participating, non-participating, essentially this is what rights do shareholders have when you actually sell your company. For a non-participating shareholder, usually that means they get a certain return that's capped. And a participating shareholder kind of gets whatever's left over from there. So obviously more upside for the participating, but typically the non-participating get their money out first. And you can have combinations of their combinations where they kind of get the best of both worlds, and that really depends on what negotiating power your investors have. And then finally, sometimes we'll have some anti-dilution protections, which more so in the later rounds with VCs and whatnot, but essentially it gives those shareholders the ability to keep their equity portion or valuation in future rounds. You can also have other kind of special rights that are not actually attached to the shares, but are contractual rights. And the difference here would be if you sell the share, those rights wouldn't continue unless the contract comes along with it. And there are some examples there. So the relationships are really governed by kind of three documents typically. It's the articles and the shareholders agreement, and sometimes the subscription agreement or whatever agreement. There could be separate agreements with more rights.
So underneath visually, I guess the directors in the or the shareholders in the organization are the directors. And as Sam mentioned, the directors are generally elected by the shareholders of the company. And with limited exceptions, the directors can themselves sort of add more directors to the board, but generally think about it in the way that the shareholders, who are the owners of the business, are electing the directors to the board. And there's some corporate requirements in that regard. There's eligibility requirements. You're restricted if you're, in some cases, if you've been bankrupt or you're not the age of majority or issues like that. You have to have at least one director. You can have as many directors as you want in theory. There's practical considerations with that, of course. And then some jurisdictions have residency requirements. In BC, you don't have to be a particular resident of a particular jurisdiction to be a director. But in other jurisdictions, there's a requirement that, for example, there be at least 25% of the directors are Canadian residents, for example. And the key thing to be aware of when thinking about directors is just jumping around on me. All right, one push. The directors are managing they're ultimately responsible for managing the business and affairs of the company. And so the shareholders aren't there operationally day to day. They own the company. They elect directors that are responsible for managing the business. And we'll talk a bit about where the delegating duties, but that's kind of the statutory regime. And with that in mind, the directors then have certain duties under common law or statutory duties, commonly referred to as fiduciary duties and duty of care. And so the director always has to act in the best interest of the company and its stakeholders. And so when you're wearing your director hat, you have to be mindful of kind of the decisions that you're making as a director of the company. Are those for the best interest of the company, not yourself personally or one particular shareholder, for example? There's potential personal liability as a director. Generally, the most sort of common avenues of that are a breach of those duties I mentioned. If you're not acting in the best interest of the company, sometimes you're maybe treating the company like your own personal little piggy bank, which is obviously not good if you have other shareholders that you're responsible for. But also, unpaid wages can sometimes result in personal liability for directors, as well as unpaid taxes. And then similarly, where the shareholders are kind of determining who the directors are responsible for managing the business, the directors then in turn are appointing the officers. And so they're determining who's actually running the day-to-day. So they're delegating their responsibility to manage the business to the people that are actually operating the company. So directors are usually in their capacity as a director, not operating the business. They're not there every day. They're sort of a supervisory role, strategic or sort of directional, setting the direction of the company, but they then elect or determine who are the officers and give them delegate responsibility to manage the business. So usually depending on the title that the person is given, there's kind of assumed responsibilities associated with that. The directors can also specifically delegate certain authority to certain other individuals in the organization. And then these officers are ultimately responsible for actually carrying out the day-to-day affairs of the company and running the business. And at this point, I think it's probably helpful to mention or think of this in a way, but in the early days of the company, whether you're a solo founder or you've multiple founders, you may all be shareholders, directors, and officers and employees. And you have a different hat on depending on what exactly you're doing at that particular time. So you have to be mindful of that. If you're making a decision in your personal interest as a shareholder versus making a decision as a director of the company from a strategic perspective, or if you've got your CEO hat on and you're managing the day-to-day business, sort of different considerations in that regard. And it's very common for a startup, for the founders of the startup to wear all of those hats and just be mindful of which one they have on at any particular time. And then officers, well, actually, I'll just pass it over to Sam for this one.
So officers, our management high level and to kind of run the day to day and execute, you'll usually have either employees or consultants. So for employees, normally we say that they have that master servant relationship. The employer can direct and dictate how the employee does the work, the timing, etc. Employees are economically dependent on the employer, and they get certain entitlements under the employment standards legislation in the province. So, in BC, there's minimum wage, overtime, vacation rules, etc. For employees, they can be either for indefinite term, full or part-time, or they can be for a fixed term, like a certain start and end date. And employers have statutory obligations with deductions and remittances and that type of thing. It's quite typical to operate without strict employment agreement, but we as lawyers always think it's smart to have one in place. It can provide more certainty on vacation entitlement, severance between the part, and this could limit future liability. In particular, with respect to severance, if you don't have a specific severance clause in your employment agreement, you're kind of subject to common law, which is typically more generous to employees.
Yeah, I guess said another way, there's no legal requirement to have an employment agreement for each employee, but definitely have one. And I think there's a lot of benefits to it, but the second bullet there that Sam's talking about is really critical for anyone that's touching your IP.
Yeah, so for assignment of IP, typically, it's best practice to require the employee to have a positive obligation to take steps to confirm that the company owns the IP. Obviously, for a lot of you, that will be the main secret sauce, and you want to be very protective of it. And then you might have other type of provisions in there to non-competition, non-solicitation. Those are often harder to enforce. The courts don't love them, but essentially non-compete means that if someone leaves your company, they can't compete against you. Usually that won't only be enforceable for your very high level folks, because essentially courts don't like it when you prevent people from working. Non-solicit, that essentially means you can't kind of go back and try to take customers, take employees if you've left the company. That one is more enforceable. So next we have contractors, and to contrast it with employees, independent contractors do not have employment status. They don't get the traditional employee benefits and they're not protected by the employment standards legislation. So the difference generally speaking, is that independent contractors assume the risk of completing the project on their own. Usually they can retain control over how they do the job, when they do it, etc. They're allowed to contract with other companies to do the work. Usually they use their own equipment. And typically what will happen is the independent contractor will submit invoices to the company. They'll have their own obligations to remit and pay taxes and whatnot, but that's on their end. It's not the company's obligation. The company is not obligated to do any withholdings. And there's also generally no severance obligations and that type of thing. Your contracts might have some sort of termination clause in it, but there's no common law on severance for contractors. So you'll often have the similar type of provisions you see here: confidentiality, assignment of IP, non-solicit. Generally speaking, I think that for the IP assignment provisions, it's actually more important in the consulting relationship. In the employer-employee relationship, there's you're kind of deemed to, if you're doing something as an employee for the employer, you're kind of deemed to that the company owns the IP because you're doing it for me. Whereas in a consulting relationship, that isn't there. So you will definitely want some sort of provision that clearly states that you own the IP, the company owns the IP, even though it's the consultant doing the work. And then our next section is on tax.
Thanks, man. So just a bit about tax implications of the two consultants versus employees. So one thing is that like you want to be sure if like an individual is a consultant or an employee. And so the determination there is actually it depends on what the individual is doing, what the worker is doing. So like the courts do look at what the agreement is between the worker and the organization, but that's not determinative. Like what is determinative is like the factors that Sam mentioned earlier, as to like who controls the worker, how is the work product delivered, how is it done, who determines what that is, all of these things, and depending on which way those factors go, one points more towards an employment relationship. So that would be one where like the organization has more control over the worker. And one would point towards the consultant relationship. So that said, like if there's an agreement between the organization and the worker, then it's more likely that courts will frame the analysis that they're going to carry it out to be like in line with that agreement. Like they'll believe what's in the agreement unless there's like good reason not to believe it, effectively, or another way of saying that. So that's all really important because, well, for a number of reasons, some of which Sam mentioned. For tax, that's really important because, well, there are a lot of requirements put on the employer that wouldn't be there for a consultant. And so the employer would have to withhold for source deductions for income tax, CPP, EI, employee health tax, all of these things. So, and if they don't do that, or if they don't facilitate that, so a lot of that stuff is not actually the tax of the employer. So that's these are all entitlements of the employee, and like source deductions for income tax, that's not the income tax of the employer, that's the income tax of the employee that the employer is facilitating the payment of, because that's the way our tax system works, so that we don't have a whole lot of people who are getting paid but then don't actually file their income tax returns and all that. So that the government doesn't have to chase them in order to get it. So if an employer doesn't do that, then there are penalties, and they can be pretty harsh penalties. And so Geoff mentioned that directors are liable. Well, one of the things that directors are liable for is like if those source deductions are not made, or if they're collected and they're not made, then that's the liability that can attach to directors. Anyways, so employees, well, like basically anything that the employer gives to an employee is going to be considered employment income. So there are rules associated with some forms of compensation, which we're going to talk about. Consultants, basically anything that the organization gives to a consultant would be considered business income for the consultant. And the consultant may not be an individual, it might be like another company or something that's operated by that individual or whatnot, or for individuals. So there might be GST that's payable, possibly PST, but less likely to be PST as well. Next slide, please. Oh, actually, so I mentioned that there's anything that you give to an employee is going to be employment income for the employee, but there are three main forms of employment remuneration. So one is cash, just salary or bonuses, and the other two are shares and stock options. Shares and stock options for tax purposes, at least, like sometimes they're considered like together because a stock option can be issued with such a low exercise price or no exercise price that it's effectively just a provision of a share. So if these are provided, generally, when I say generally, for startups, then there would be like no tax event at the time these are provided. So that's subject to like that's like part of the tax rules. Yep. So yeah, so stock options, like there's a specific provision in the Act which sets out how stock options are to be taxed, and the main provision part there is that they're not taxable on receipt. The one difference is for shares. If shares are provided by some types of companies, then those would be taxable on receipt. but startups usually are not that formal companies. So like, so we'll talk about Canadian controlled private corporations. Most startups that like you guys, most of you, possibly all of you, if the business that you have, it'll be like a Canadian controlled private corporation. And in which case, like the shares and stock options, they're considered together, because if your organization were to provide either of those, if it's a like Canadian controlled private corporation, then nothing happens for the employee. It would be okay. So like normally that's like when options or shares are issued, that would be on grant. So at the time of grant, there's no tax for the employee. At the time of vesting, so sometimes like there's a schedule. Options are granted, but
Still can't hear you.
can you hear me now?
Did we lose the mic?
The light is on. I can speak up.
Yeah, we're good.
You can hear me now?
Yeah.
Okay, I'm just gonna,
No, it was working.
oh, it's working now. Okay.
Oh, yeah.
Apparently it cuts up.
Yeah, I can hear it in the.
Yeah, I can now hear the, sorry about that. So I'll just like start at this page, but if you guys have questions about some of the stuff that went on, we can talk about it after as well. So no tax on grant for the employees. So like when the shares are issued or the options are issued, then generally no tax, provided the issuing organization is, or the granting organization is a Canadian controlled private corporation, which most startups are. And then sometimes the options or the shares that are granted, the employee won't have entitlements to them until a later date. So for the reason that you may want the employee to stick around for a period before they're absolutely entitled to those shares or those options, so that they can exercise them, sell them, and whatnot. And so that would be the vesting time. And if there's a vesting event, then generally there's no tax event there either. And after that, like an employee may choose, if it's an option that they have, the employee may choose to exercise the option. So the option will have like a certain exercise price or strike price set out in the option agreement. And for Canadian controlled private corporations, that could be quite low. There's no real requirement that it be like a certain number or not. So when that's paid, that would be when the option's exercised, and then the employee would get the share. And there's still no tax event there. It's after the share is held for a period of time and then sold, it's the time of sale that would cause the tax event to be realized, like to occur. And so then at that time, like the entire value of the share that was sold would be included in the income of the employees. It's an employment benefit. And then if certain conditions are met, there's also like an offsetting deduction that's available called the stock option deduction. Stock option deduction, and so that's intended so that the overall economic advantage of holding an option is the same as if you're like holding something that gives you capital gains rates. So like an employee, like by getting an option, they're not actually holding like property in the sense that they're holding property, but like because they got it through employment, and it's to be included in employment income, which is taxed at a higher rate. You don't get capital gains rate on that property. So like, but the act is the income tax legislation's set up so that the effective rate is capital gains rates. And you may have heard that there's been a change to capital gains rates recently. And so what happens is that the deduction that I mentioned earlier, that would offset the employment income inclusion. So that amount has been lessened, or it will be on June 25th, provided we actually don't have legislation that sets this out, but that's just what the announcement said. So that's what we would expect to happen. So one of the conditions actually for a Canadian controlled private corporation is that after exercise, the person has to wait 2 years before the shares are sold in order to have access to that deduction. So that's one of the key things that have to be kept in mind. And if you don't have that 2-year wait period, then you can't get the deduction unless like the non-CCPC conditions are met, which we'll talk about a little bit later. So non-CCPCs are basically like, well, they're organizations that are not Canadian controlled private corporations. So that would mean that they're either controlled by public organizations or public companies, or they're controlled by like non-residents, or some combination of the two, or like some combination of the two have sufficient shares that say that the Canadian is not controlling. Anyways, so for employees of those organizations, they have slightly different tax rules that apply to them, and there wouldn't be a tax event for them generally on grant of an option or vesting of an option, but there would be on exercise. So for them, the deferral only goes up till exercise of the option, and then at that point you would get the employment deduction as well, or the stock option deduction. But they would only get it if the strike price, the exercise price, was at least the fair market value of the share at the time of grant. So that's the condition that often startups, they may not accede to that, because like they may give an option that's at like a cent to exercise, but the share price is $1 at that time. On the understanding that, well, with stock option deduction, like they don't have to worry about like this FMV condition. The problem that can arise for that is like if somebody doesn't hold it for 2 years, then you need to rely on the general one, and then you're into a bit of trouble because that deduction is going to be denied to the employee. So we've talked about consultants and employees. Stock options to consultants as well. So some plans will set this up. So like normally stock options are issued under a stock option plan. Like it's a good idea to have one of these to provide rules as to like when options are going to be issued to employees, so that they know what like without the rules that you can have disputes that might arise. Some of the plans may discuss consultants, some don't. But I like what I've seen is that like often organizations don't really differentiate. So some consultants may end up getting options. The thing to be aware of that here is that anytime a consultant who is like a consultant might be an individual or another business, like they're in business to make money from their activities. So, and they're supposed to record their income in a particular way. And like now, like they're getting these options, but they're also income for them. And they're not subject to like the employment stock option rules because they're not employees. And so at the time of grant, when these options are issued to these consultants, those consultants would have to like have employment or like regular business income. And so they would have to go out and figure out what the value of those options are at that time. And options do have value even if the exercise price is pretty high. So like we have in the money options and out of the money options. If you have an out of the money option, so like at the time, like if you're holding an option and the exercise price is $10, but the share is only worth $5 at the time, that doesn't mean that the option's valueless, because there's the possibility over the like before that option expires that it may become in the money. And so there has to be some value associated with that possibility. So if you actually go out and value what the option is, like it's going to account for this. And so the value will not come back as zero. It might be close to zero, but it might also not be close to zero, depending on what the factors are there. And so like a consultant would have to like, well, I guess they don't have to, but there's good reason to actually figure out what the value of the options that a consultant gets are. And the consultant should include those in the business income. And the reason for that is in some cases, like consultants also, when they exercise the options, they may not have a tax event, and they may be able to like hold off on paying further tax on in respect of the option and the share they receive until sale of the share, provided like on grant they handled it properly, and a bunch of other conditions apply. So, but anyways, I just wanted to make a point that like it's you have to be mindful about like what to do with the options when you get them at a consultant. So the next. So apart from options and shares, Oh, I should note, if you have a non-CCPC and that issues shares directly to an employee, that means that there's no exercise time, right? So in that situation, the employee has like an immediate employment benefit. And because there was no exercise price, that also means that there's going to be no deduction. Like there's no stock option deduction available to that employee. And so there's going to be tax that arises in respect of that year of issue of the share. And for employers, it's important to keep track of these things because sometimes there is also the requirement that the employers have to withhold at source on employment benefits that their employees receive, including from stock options. CCPCs, so Canadian Controlled Private Corporations, have somewhat of a relaxed regime, like they don't have to pay as much attention to this, but non-CCPCs have to be very mindful of this because it would, if they're off on their source deductions, remittances, that could be a big problem for them later. Anyway, so cross-border employees. These are other issues to be aware of if you're a Canadian business. So if you have an employee that's working outside of Canada, there's a possibility that that employee has to pay for like tax in the jurisdiction that they're located in. There's a possibility that the organization that employs that individual has to pay tax in or make source deductions in that jurisdiction as well. And there is also another possibility, which is more serious even, that there might be a permanent establishment as a result of that employee acting in that or working in that jurisdiction for the employer. So a permanent establishment is like effectively it occurs where like the business has like another place of business in another jurisdiction. So like if your startup is in Canada, but you have an employee that's in Seattle or something, and like maybe that employee works out of an office, then there's a chance that your business may be considered to have a permanent establishment in the U.S. And if you have a permanent establishment there under the Canada-U.S. tax treaty, it's possible that your business may be taxable in the U.S. According to how much income is earned in the U.S. And there's complicated rules to figure that out. Even if there's no tax, it's a huge headache to figure out how to like pay U.S. taxes, how to file for U.S. tax returns, even if you have a no return, and so on. And I would say U.S. is probably the nicest jurisdiction to have an employee in. If it's another jurisdiction, it's more complicated still because it's more foreign. It's harder to find somebody to help you with that. And I don't think any of you are in this situation. But like if it's a non-Canadian business that has a Canadian employee, then the reverse problem arises where like the Canadian tax system will have to possibly attach to that business as well. And the last observation here actually is that if you have employees in different provinces, so although you may be deducting at source at a particular rate in accordance with like what the employment tables for BC say, that might not be enough for that employee in the other province. Generally, that's okay unless, well, it's okay for the employer anyways, unless like the employee is working out of an office or something in the other province. But the employee should be mindful of that because if they're not, then they may have a higher tax bill when it comes time to file their taxes, because if the employee is relying on the source deductions to make up the entire tax payment that they have at the end of the year, well, they may be far off from that mark if like the provincial source deductions are really inaccurate for their province. Just something that you don't want to be surprised by on April 30th. And I'll pass it back to Geoff.
Yeah, just really quickly, this is kind of the last category in that structure that we had showed you of different stakeholders, I guess, in the business. And this is somewhat unique to the context of a startup because most companies don't really have an advisory panel. There isn't like a legal concept of an advisory board or advisory panel, but it's commonly referenced. So I think it's probably important to mention. These are usually just individuals, other sort of advisors that are available to the company, the founders, the board, management on an ad hoc basis that sort of form a group that are industry experts usually and usually not sort of not paid with cash compensation, but usually participate in a stock option plan or some kind of equity, or maybe investors themselves. And so it's just worth mentioning. I think it's not like a board of directors. It's a legal kind of implication to it, whereas your advisory board is really just a group of consultants to the business. But it's a very common thing to have, and there's some sort of industry standard ways to approach it.
I think we kind of already covered this. Geoff already kind of covered this, but just be mindful of conflicts of interest especially for new stage, early stage folks will be wearing multiple hats. For example, often you'll be a shareholder as well as director as well as an officer, which are conflicts of interest within the structure. You might be directors of multiple companies. So conflicts between companies and also potentially conflicts between the company and counterparties. Just keep in mind in particular, as a director, there's statutory obligations you have a fiduciary duty to the company. So you have to act in the best interest of the company, and breaches of that can lead to personal liability. So just keep in mind there's always going to be these conflicts of interest, and you have to be mindful of which hat you're wearing. So now that we've sold you on the corporate vehicle as the way to start, these are kind of the initial things you'll need to think about when you're incorporating. First is kind of where you're incorporating. People often talk about, very broadly, they want to incorporate a Delaware company, etc. Keep in mind that and the rationale is always that Delaware is a very sophisticated jurisdiction for corporate law and is very corporate friendly. But keep in mind, BC is a pretty friendly jurisdiction with respect to corporate law, and there's other jurisdictions in Canada that are also kind of getting there, including Alberta. They've made multiple changes to their legislation to make it more investor friendly. There's other reasons that we think it makes sense to stick to Canada. If you're like yourself and a bunch of Canadians. Sometimes investors don't like to see offshore companies. They're Canadian. They know what, they're used to the Canadian structure. So they would prefer a Canadian entity. Or certain government grants, they're only available to Canadian companies, so they have to be incorporated in Canada. And then tax and employment issues get simpler if you're just incorporated in Canada. So unless really, there's a good reason not to be incorporated in Canada, that would always be our suggestion. If there's a large investor who's demanding and pounding the table that it has to be a Delaware company, then you might want to consider it. So when you're incorporating in Canada, really you can either incorporate within the provinces. So each province has their own statute, or we have a federal statute too, the CBCA and the Business Corporations Act. Both are kind of fine and are both investor friendly. There's specific differences that you can talk to a lawyer about. We like to say that BC is more investor friendly, but you'll have different opinions. So now you've chosen where you want to incorporate. The next is kind of the initial very, very high level structure. So, our suggestion would always be to have a very simple structure. The more you complicate it when you're trying to do things in the future, just adds complication, and investors initially want to have just kind of a clean structure. So our suggestion would be have, just a simple structure with unlimited number of common shares and what we call blank check pref shares. Pardon?
So we took that out.
So blank check pref shares are just kind of giving you ability in the future. And so you say you don't like press anymore? Okay, we'll cancel the press now. Just comments. And this is really, the folk coming in, they see the structure, they are more comfortable with it. So, what we're trying to say here is, you want to avoid what a lot of holding companies will have: multiple class share structures, multiple dividends, multiple voting classes, etc. You just want to kind of avoid that if you're doing a startup. Generally speaking, you might have to, as you go, you're going to get more complicated, and typically The changes in your structures and including, having debt in there, different types of equity, including preferred shares, preference terms, shareholders agreement, all that will be dictated by your future investors. The more leverage they have, they can push. But what you're trying to avoid, at least initially, is one, avoid issuing any secured debt. The way secured debt works, it all gets stacked on top of each other, and the first person in gets that initial priority. So, giving that up is a big deal, and you want to avoid giving up that first priority secured security until you absolutely have to. As we mentioned, avoid multiple share classes, and then we would say that you should avoid offshore incorporation as well.
Thank you. So as you may have guessed, there's a lot of tax considerations that impact how you're going to finance the new company. And like just anything between them, like there's different tax issues that arise. So the simplest one, it would be like, well, it's either you can issue shares with financiers, or you can get debt, take on debt. And so if the considerations there as well, like, well, how do you give shares to an investor? Do you provide new shares? Do you provide existing shares? Well, what's the difference? Well, if you're providing new shares, that would be like new shares would be issued by the company, and so the money would go into the company. But if you're selling existing shares, well, these would be sold by a shareholder, so the money would go to the shareholder rather than the company. So then it would have to be transferred in later somehow. The problem for the investor would be that if you're getting new shares, you can get a new class of shares. That's often appealing because then the paid up capital addition can be restricted to that class of shares. So that would mean that like there's an advantage to having like paid up capital that's associated with shares, and when it comes to paying dividends and whatnot, or getting money back from the company. And so you don't, like, if you're investing, then you don't want to dilute your paid up capital so that like other people will also benefit from it, because then you won't. And so like that might be important to you. So you may want to get like a new class of shares that would, and if you buy like somebody else's shares, then you inherit the paid up capital, and so you don't get the addition.
Excuse me, the money goes to let's say you need a trust account on your company. So if it goes to the share, the money goes to the share of the investor. The investor is required to have a trust account too, and the money goes to the investor account of a share.
I'm not quite.
Say the money goes to the share.
So like if somebody's, but like my point is only that if somebody is selling you the shares of the company, like then like the money is going to go to the person who sold you the shares rather than the company.
So in the other option, the other example you did before.
Shares issued by the company.
Yeah, then it goes directly to
The money goes to the company.
Yeah, so
So
that would
usually
be
what you
bank
do when you're
account.
raising money. I guess,
Yeah.
It goes to the company, not to the share.
Generally.
From the share, that would be a trust account, will go to the,
Yeah, I don't know that, like, there's no trust account requirement for either of these.
or immigration, there is a trust account.
For immigration, I guess we're talking about purchasing shares of a company.
So anyways, like the choices here, like it may seem like it's the same thing. Like in either case, the finance, like the investors ending up with the same number of shares that they would have otherwise. But because there's like there's nuances, there's important differences between the different options there. Like it's good to know exactly like what the deal will be, right? And so the other option is debt. And so with debt, like there's like a lot of issues can arise. For example, like if you have already have an investor that has a certain number of shares in your company, and that person wants to invest more in the company, but doesn't want to take back shares, they want to take back like secured debt, for example. So it's a big investment. But like the problem would be that if the company is trying to deduct all of the interest on the debt, well, some of it might not be deductible anymore. If like your investor is like a non-resident and is holding like that certain number of shares, and so that would be problematic, because like that would be quite a lot of money that's being paid out in interest that cannot be deducted by the company. And so it becomes way more expensive than would have been bargained for. So that's something to be mindful of, like who the investor is.
Better to have investors being kind of.
Well, I mean,
Residents
it
kind of-
depends. Like, you know, there might be other factors that suggest that it's a good idea to have like that investor come in, but it's by a different route. And so the point is, like, you know, all of these decisions have to be made very carefully, and these things have to be thought of before like anything gets signed and the money comes into the company. Generally speaking, like, I mean, I agree with what Sam has said, that like a simple structure is good. It's hard to predict all of the things that might arise because it's not in the hands of the company. Like, it's in the hands of other people who you don't know what what the considerations are important for them. So it's just easier to have a flexible structure that you can change as you need, rather than one that tries to anticipate every single problem that will arise. So one thing that I'll note is, like, we talked about CCPC, Canadian Controlled Private Corporations. We talked about how the stock options that are granted by CCPCs are more advantageous for employees than stock options that are granted by non-CCPCs. By virtue of like that alone, a company should be careful about losing its Canadian Controlled Private Corporation status. That status depends on who the shareholders are and who controls that company. And so if you're looking to have an investor come on, then depending on the terms of the investment, it may be that the control could shift, or at least like could shift to the degree that it's no longer a CCPC. And so if that's going to happen, you should know about it before it happens, because it's going to come with a bunch of tax consequences that will impact the business later. Other things, well, like if a CCPC benefits from the enhanced SHRED benefits, there's a larger tax credit. It's refundable. They're refundable up to 3 million. Like that's a big deal, because for startups, like early stage startups, like if it's not refundable, then effectively it's not that useful, because it may be that like you really do need the refundability in order to finance, or like, you know, finance the activities of the business in the early stages. And so losing that would be a big problem. And of course, like CCPCs, like shareholders will get the lifetime capital gains exemption on their shares if they were to sell them potentially. And I will note, along with that capital gains inclusion rate increase, there is an increase in the lifetime capital gains exemption limit from what's like 971,000 right now to 1.25 million. And so they've increased the capital gains inclusion rate, which means that capital gains taxes have, there's no actual capital gains tax, but like the income tax associated with capital gains has increased as a result. But because of this increase of this like a lifetime capital gains exemption limit, this is pretty valuable. I think like you can save a fair bit more tax under this revised limit. So if you were to sell your business for 1.25 million, say. And the other thing is that CCPCs also get the reduced tax rate on their first $500,000 of income. It's 11% rather than 27%, which is pretty important. I mean, it's important for the business. It's not, I'll leave it at that. There's more complexity there when you look at dividends and taking stuff out of the corporation, but that won't happen for startups for a while. And we've already kind of talked about this. Well, what is a Canadian Controlled Private Corporation? And we've talked about why that matters. I'll just say again, it's a corporation that's resident in Canada, incorporated in Canada, whose shares are not held by non-residents or public companies or other entities controlled by non-residents of public companies, so such that they're able to appoint the directors. So there's no one person that can appoint the directors. And if you add all of those like bad shareholders, so non-residents controlled by non-residents, public companies controlled by public companies, if you add all of them up, they don't hold such number of shares that they can also then appoint the directors. So if that's not true, then you have a CCPC. Pass it over to Geoff.
Thanks. So I'll walk through kind of the initial cap tables setup and then this kind of general roadmap as that leads into raising capital for the business and all of this kind of legal structure around that. So often founders that we're working with talk about issuing founder shares. And generally when you're starting the business or you're formalizing the business and incorporating, either as a solo founder, you're going to issue the initial sort of shares to yourself, or as a group of founders, you'll determine amongst yourselves how you're allocating the equity of the business. And there is no legal concept of founder shares. There's not, you know, the shares are just shares. There's not a different type of share that's a founder share. But from a, you know, typically these are referred to as founder shares because they're issued at a nominal price to the founders. There's no actual cash really paid for them. It's in recognition of how you're anticipating the ownership to look like and as you kind of earn into it over time, because often you're also not paying yourselves any cash salary. So you're kind of earning into the equity that you're being issued at the outset. As we talked about, you know, the share structure at the outset is going to be fairly simple. Often you'll just have one class of common shares, and each of you will be issued shares from that class at some nominal price. And then also a couple of things to keep in mind when doing that is sometimes we work with founders that have issued themselves or have set it up themselves and they've got 100 shares each or something like that. It's a lot easier to manage as the company grows when you've got a much larger number of shares. The number is frankly arbitrary at the outset. So often you want to have 5 million or 10 million shares total amongst the group of you to make it sort of an easy number to divide as your valuation increases. Generally, these founder shares are really only issued to the founders and maybe some sort of key early hires. But as the company develops, you're really relying more and more on your stock options as you go. We talked to kind of the implications of doing that. So often these are really just the shares issued right at day one. And usually they're issued subject to vesting. And so there isn't, similar to there not being a real legal concept of founder shares, there isn't a legal concept of vesting that can attach to the shares, but you typically will set up a contractual arrangement where the shares reverse vest. So there's a diminishing right over time to repurchase the shares. So you're earning into them, they become vested and they're no longer subject to forfeiture. And so one exception to the, you know, you're always issuing just founder shares at the outset. Sometimes a founder might leave before they're fully vested. Unvested shares get clawed back. You might bring in someone new and effectively reallocate those founder shares to them. And also when setting up the initial sort of share allocation, often we find it's simpler and easier to notionally set aside a number of shares for your stock option plan. So keep that in mind when maybe you're going to issue 8 million shares to yourselves as founders as a group, and then have 2 million shares under your stock option plan, and then you have sort of 10 million total, and it's just an easy number to work with. Again, it's mostly arbitrary, but it's just sort of more of an easy thing to do. And then yeah, so these are kind of the mistakes we encounter: is issuing too few shares, issuing a bunch of different classes of shares, not having a vesting arrangement in place where there's multiple founders. I think that's pretty important from day one. And then just bringing too many people on your cap table right out of the get-go. A lot of people say, hey, this person's helping me, and I've got all these other friends and advisors, and I just want to give them all founder shares. It really should just be those people that are dedicating their full time to the business once you're kind of decided that this is what you're going to kind of build. And so once you've got that set up, then you're now possibly out looking for funding. So there's kind of two broad categories, and I'm sure you're getting a lot of help learning about non-dilutive funding opportunities. And really, like, that's the key place to start. Is there's tons of programs, tax incentives, and the like. Maximize those as much as you can. And then there's various other sources of funding, other sources of non-dilutive funding, which could be just traditional bank loans, secured and unsecured debt, amounts that you have to eventually repay. Grants and credits are usually better. And then dilutive funding. So that's generally issuing equity, either issuing shares at a fixed pre-money valuation to investors, or issuing convertible securities that ultimately, on certain events or certain exercise rights, convert into shares. Most of the often companies will kind of end up using both, or may bootstrap and avoid the dilutive route altogether. So sources of capital, and these are often sources of capital for equity, but these could be lenders as well in theory. And there's a few kind of general categories that I'll walk through. I know you guys had a session on fundraising, so I might have talked about this already, but you know, you've got your friends and family investors. These are sort of your earliest investors that are investing in sort of you and your idea and aren't really looking too closely at your corporate structure or your patent applications and things like that. It's what we call love money. And there's really sort of not a lot of kind of legal structure around it or complexity to it. It's kind of as simple as possible investment into the business. Then you have individual angel investors, which are also individuals and could kind of sometimes be in the friends and family category, but usually high net worth individuals that sort of invest either as a hobby or professionally, but usually with their own funds. And they're more sophisticated, obviously, and so have higher expectations for what their investment structure looks like, what they're going to get back, what the company has done from a legal structure and business and financial structure. But they're sort of making early investments that are very high risk, high reward. There's limited due diligence to do at the stage that they're investing. And it's often, again, an investment based on a relationship with a founder or a belief in a founder's ability to execute, as opposed to a business generating revenues and investing into to sort of a profitable business at that stage. But the valuation is still quite speculative, and often there's some desire to avoid even sort of settling on a valuation. I'll talk about that a little bit more. Then you have sort of seed venture capital investors. These are professional investors that are investing often other people's money, more sophisticated institutional structure, and a structured process to their investment. Later, these investments are made later on when there's usually commercialization. They're negotiating a lot more rights attached to their shares. Sam talked about a number of the rights that you often associate with or that you can associate with shares. And while we've kept things very simple for now, bringing on institutional investors often means having a more complicated capital structure to accommodate their needs, and along with all kinds of other rights, including information rights, pro rata rights, all of that fun stuff. And then they also will typically do a deeper dive on due diligence. Strategic investors mostly fit into that same category, except they're kind of not necessarily just looking for a financial return. They're often investing their own sort of investments from their own balance sheet. But there's often a commercial relationship or potentially a path to sort of acquisition with them. And so they're just looking at the investment through a different lens. So those are kind of the sources that you're looking at. And then these are the kind of stages of the investment and what it typically looks like. So, you know, pre-seed is your, you know, founders might be putting in their own money, friends and family investment, angel investors, pretty simple, low due diligence, low structure, convertible notes and safes probably being the most common. Often we see, excuse me, it could be an investment for common shares. But again, at this stage, it's often a non-priced instrument like a safe. And then, you know, your seed round, there's maybe a similar group of investors or sort of early stage VC. Structure is pretty similar depending on how much is being invested. It could be a more complicated structure with preferred shares, sort of light rights. And then you get into the Series A where you've got an institutional fund leading it, other large investors or strategic investors. And that's generally always going to be preferred shares with all of the basket of rights associated with it. Oh gosh, something stuck in my throat. And so you know, to kind of focus a little bit on the earlier stage right now, but you're all possibly familiar with what a safe is. These are very commonly used in the ecosystem. The key is that it defers your valuation to a later date when a professional investor is able to kind of really negotiate a value with you, although there's a lot of subjectivity to that as well. But it limits the amount you need to negotiate in order to get investment dollars in a way that's still fairly protective to the investor themselves. You're really just talking about a cap on the valuation, a discount rate, whether or not they have kind of you know, whether or not they'll benefit from a, you know, if you do that around later, if they can benefit from that, if they get pro rata rights, any other sort of information rights, that kind of thing. But it's really cap and discount are the big ones that you need to worry about with the SAFE. It's not debt, so it doesn't have to get repaid. Eventually, one day it'll convert into shares unless you sell the company first. So that's nice too for the company, as you're not taking on debt. There's no interest rate. There's generally no maturity date. It's just a simple, here's our money. We'll figure out later what the price of the shares are worth. And then similarly, I mean, convertible notes are very similar, except that it is debt. There is a date at which it might have to get repaid if you haven't done an equity financing to convert the note. Usually there's an interest rate attached to it. So, you know, you've got the same valuation cap and discount consideration, but now you're also negotiating possibly interest rate maturity, whether it's secured. Try to avoid that at the sort of pre-seed seed stage. But it similarly converts in your next financing or potentially if you have an exit. And then the last thing on the fundraising topic I'll mention is the EBC tax credits. And I don't know how much you guys have sort of heard about this already, but it's, you know, ubiquitous in the ecosystem here. If you're raising money from BC-based investors, ideally they're going to want to get there's tax credits available, and they're going to want to get the tax credit for their investment if they can. So I always suggest looking into this early in your fundraising journey. You can register as an eligible business corporation. There's a number of different categories and eligibility criteria. Not every company's eligible, obviously, but look into it. And essentially, investors get a 30% BC tax-paying investors get a 30% tax credit on their investment up to certain limits. I could we could do a whole other hour session on this topic alone, so I won't really get into it. But just to flag that it's, you know, look into it. Don't just ignore it. Over to Sam.
Okay, so now that we kind of know how you can raise money, the question, you know, is how do securities laws come into play? So there's also some confusion that securities laws only apply to, you know, big public companies or exchange listed companies, and that's actually not true. The general rule is all companies who issue shares in Canada to Canadians would be subject to securities laws in Canada. So securities laws essentially will limit kind of who you can go to raise money and sell shares. You know, the point of this next section is really just to give you a high level understanding of Canadian securities laws, but obviously we would suggest getting more specific legal advice if you're actually looking to do a financing. And also, you know, keep in mind securities laws, you know, when I'm speaking to them here, it's really in BC. Securities laws are different across the country, provincially and in the territories. Generally, they're pretty much the same, but there are specific differences. So you'll want to get specific advice, and certainly if you're raising money in US or you know offshore, certainly the foreign jurisdictions will have different securities laws. So at a very, very high level, starting from the beginning, the general requirement is if you're selling a security, which would include things like shares and safes and convertible notes, to a Canadian, where Canadian securities laws will apply, you either need to file a prospectus or you have to have an exemption from a prospectus. You know, generally speaking, a prospectus, you only file a prospectus when you're one of those larger exchange listed, you know, TSXV listed companies. You know, something like an IPO is a prospectus offering. And when you do an IPO, you obviously become public. You know, a prospectus is incredibly detailed and, you know, costs a lot of money, so it doesn't make sense for a small private company. However, under securities laws, I mean, the idea is that, you know, if you give everyone enough information, they can make their own informed decision to buy these shares or not. With that being said, for non-public companies, where producing a prospectus just wouldn't make sense, you can rely on exemptions. And these exemptions effectively allow you to raise equity from certain investors or complete certain transactions where the disclosure in a prospectus isn't required. So these are kind of at a high level, the exemptions, and we'll talk about a few of them more specifically. But whenever you're relying on these type of exemptions, just keep in mind the legal documents will need to have specific language to document the exemption, and in some cases you'll need specific forms, and the shareholders to give specific reps to the company. So again, this is why we would suggest getting some specific legal counsel. So the first one of these typical exemptions is the friends and family exemption. Friends, family, and business associates. So essentially, you can sell to either director, senior officers, or control persons, or family members of a director, senior officer, or control person without creating a prospectus. The idea is that you have these investors have a specific sufficient connection with someone running the business or really in the business, that if they need information, they can go get that information from the person without having to rely on the prospectus. Under that same exemption, you can also sell to close personal or close business associates of a director, senior officer, or control person. And again, there's no limit on how much you can raise here. This exemption, kind of people like to rely on it. Flip that slide. This exemption, people often see it as very broad because they say, well, friends and family, that friends can be, have a wide definition. Business associate, can that just be someone, I have a consulting relationship with, something like that. But keep in mind, for this exemption, it does actually have very tight limits. It is not personal friend, but it's close personal friend, close business associate. So that close is a very important part of that definition. So, essentially someone's not a close personal friend just because, you're in some sort of organization together, religious group together. You're not a close business associate just because you're a client or former client, things like that. Or if, you've connected through social media and all that.
How do you prove you're a close friend?
Yeah, so I mean, it's always tough, and to be honest, where you get in trouble is if the commissions come after you, and then you have to start proving stuff.
You always ideally want to, there's a number of these exemptions that Sam will go through. Some of them have sort of objective criteria, like you have X dollars or you meet certain tests. Objective ones are always going to be better because you never have to worry about it. It's a black or white. These are quite subjective, and so you maybe take on a bit of risk that a loose relationship and you think maybe you're close friends, but the Securities Commission could disagree with you.
Yeah, and honestly, like as initial startup phase, you'll see the later ones involve high net worth individuals. You don't necessarily have access to them, but friends, family is an easy one to define, and also likely someone you're going to go to anyway when you start. And so this one is one that a lot of people like to or initially will rely on, and you just have to be careful because again, it's not just any friend of yours that you can reach out for money. The Securities Commission, the point of it is to kind of protect the investors, and so they will take tight views of it. The non-legal test that we just kind of use, and it won't be what the commissions come to you with, but the non-legal test is, do you know how many bathrooms are in this person's house, right? So you've been there enough, you know them that well, and at some point, if you start doing filings and whatnot, the regulators have kind of algorithms that test and try to look for people who are using this too much. If the regulators see that one person has about 50 friends, they don't believe in that. They don't believe you can have 50 personal friends. It's more something like, you have 5 close personal friends, no matter how popular you are. So the next one is the accredited investor exemption. So this is that high net worth individual kind of exemption. And the idea here is that, if you're high net worth, you have enough sophistication with these type of transactions that you can evaluate the risk yourself and you understand the risk of it without getting a prospectus. So again, accredited investors, you can purchase any amount of securities at any time. There's no limit. The definition of a credit investor kind of includes things like financial institutions like banks, registered advisors, so things like, broker dealers, things like that. You see their corporations or limited partnerships with over $5 million of assets. And then you'll have, kind of these ones, which are usually the most useful. So these are various high net worth individuals who can meet these kind of financial assets or income tests. So, $1 million financial assets, and they have very specific definitions on what a financial asset is. Net income of 200,000 a year or 300 with a spouse, and 5 million in net assets. And again, there's specific definitions there. So the next one is probably the one that you guys will rely on the most initially. It's very similar actually to the two we discussed previously. The only difference is this one is specifically for tightly held companies. And so, essentially what this means is if you have 50 or less shareholders who are not employees, so non-employee shareholders, if you have 50 or less and certain other restrictions, you can rely on this exemption. And the benefit of relying on this exemption as opposed to the friends and family and the credit investor is that this exemption, there's less reporting requirements. So what is a private issuer? A private issuer is someone who is not a public company, so not a reporting issuer, has less than 50 security holders, not counting employees and former employees, and has certain restrictions in its articles on transfer shares, and has only sold to other folks that are qualified for the private issuer exemption. So this is where that 50 shareholder limit I mentioned before is. If you can stay under 50, there's other benefits too, like, you don't have to deal with 100 shareholders, but if you are under 50, you can rely on this private issuer exemption. So one little tricky part about this exemption is that last bullet there. You can only sell to people who are on this list. And once you sell to, one person outside of the list, then you can lose your private issuer status. So for example, if you ever get 51 shareholders, once you lose your private issuer status, it's gone. You can never get it back, even if you dip back under 50. And for that last one, has one category of people who is not on the list we'll talk about later is consultants. So sometimes if you issue options to a consultant, you can actually lose your private issuer status. So you just have to be careful there. So again, if you lose your private issuer status, it doesn't mean that you're suddenly a public company. It just means you can't rely on this exemption anymore. And you can still rely on the previously mentioned exemptions. You can still rely on the credit investor exemption. You can still rely on friends and family. The only difference is you'll have to do certain filings. And sorry, can you go back a few slides? Back. One more. Again. Yeah, there you go. So just to be clear, these are the categories of folks. If you're a private issuer, you can sell to these categories of people. And, they're kind of the same as we discussed before. Directors, officers, family members, close personal friends, etc., accredited investors. So the only difference between this exemption and the others is you don't need a filing, but you also have to be a private issuer. Okay. And then the last one we'll kind of go over here, and there are more, but these are kind of the ones you rely on, is the employee director consultant exemption. So under this exemption, issuer can sell to employees, directors, officers, consultants, etc., provided that the purchaser is buying them voluntarily. This means you can't persuade them to buy securities because you're saying that you can keep your employment here if you buy some shares, that type of thing. You can't induce them like that. A consultant has a specific definition, so you can't just call someone a consultant and issue them shares. They have to spend a significant amount of time on your business and be working under a written contract. Generally speaking, this is the exemption you'll use to, for example, issue options to people. And again, securities laws are broad enough that any sort of equity options, warrants, anything like that, you'll need an exemption. So for example, this is the one you will rely on to issue options. Yeah, and there's a number of other ones. This area financing you'll really want to get legal help with. And I know oftentimes you start off not, and that's always tricky. So you can always get in trouble.
Okay, so I'll talk a bit about some of the legal agreements that are relevant in the fundraising context, and I'll go through this, I guess, pretty quick. So I want to leave a good amount of time for questions, and then there's some sort of optional content at the end I can go through if we still have more time. So three common ones that you'll come across in the early days in the fundraising context: an NDA, term sheet, and then sort of your subscription agreement, purchase agreement, convertible note, safe instrument. I'll talk a bit about those. Non-disclosure agreements, not just in the fundraising context, like these are commonly used in the commercial context with potential sort of suppliers to the business or customers or strategic partners and the like. In the fundraising context, we often get asked, hey, should we sign an NDA with this investor? And in an ideal world, yes, you would, but the vast majority of the time investors aren't interested or aren't willing to sign an NDA with every single company they have a conversation with. And so the practical reality is you're probably not going to get an NDA with every investor that you talk to, and you may not even likely won't even bother asking them to sign one. You just need to take practical steps to be limited in what you're disclosing to them. Don't give away the secret sauce. Don't sort of give away sort of patentable inventions that you have that sort of already protected and things like that. So, and this is true for angel investors. This is true for venture capitalists who kind of often have policies around it's just a blanket no. Strategic investors, that's where it's a little bit different. You might have a commercial relationship with them already, or otherwise it's just more important to have an NDA in place. So that's where you may be pushing for it a little bit more of it. Essentially, it's an agreement under which either both sides or just the recipient is agreeing to sort of keep any information they receive confidential, broad scope of what that covers. And it usually specifies a certain period of time in which that applies.
What's the legal test for confidential, taking into account all the cybersecurity layers and violations that we can have with AI now?
Yeah, I'm not sure. Well, I'm not sure about the AI element of that question, but so you define confidential information in the agreement, so you decide what is and is not confidential. And it's usually pretty broad, just anything that's.
You have an authorized officer of the government or outside Canada accessing information from outside Canada. How can you really have confidential information?
Yeah, I think you're thinking more like those are sort of data security issues.
No real confidential information.
Yeah, I mean, those are like, you want to have good data security practices, I think, and be mindful of privacy laws as well. If you're collecting and storing personal information, to make sure that you're not disclosing that to anybody unless you're allowed to. Term sheet. This is something you'll most commonly see as part of a finance. Probably not a safe financing. We often don't do term sheets for a safe because the safe itself is simple enough. But your priced round, your Series A, your seed round, will have a term sheet, and this is just kind of a 2-page document often, or for your Series A, it might be a lot longer, but generally sets out the sort of key terms that the investor cares most about before you kind of get into the more complex legal documents with your counsel. So what securities are being offered, what's the price, what's the valuation of the company, how the proceeds are to be used, and sort of various rights that are being negotiated. And then that leads into the actual subscription agreement or purchase agreement or the actual instrument that's being acquired. And this sets out all the terms in which the investor is buying the securities. So generally, I agree to buy these shares and I, the company, agree to sell them to you. The company's giving various representations and warranties about sort of certain operations, status, share capital, protecting the investor that what they think they're investing in is actually accurate. And if it's not, they have a claim for breach. And sometimes can include an indemnity provision to specifically back that up. And so that's generally kind of the legal document in a very high level nutshell as to what you're signing with an investor when they put their money in. It's mostly protections for them and then the actual mechanical process to issue them the security. And that's kind of it on the legal documents. I think On the stock option front, maybe I'll just leave this here. We kind of talked a bit about stock option grants to some employees, consultants. We often get questions about how to set up a stock option plan. Who do we grant our stock options to? This is kind of a very sort of rough idea of how you might allocate your option pool. You know, make sure you're vesting your stock options, making sure it's kind of part of your overall HR plan. So maybe with that, I'll open it up to questions, and then if we have time, I can jump back in and have kind of a sample cap table evolution that we can go through. But it's hard to do this on a PowerPoint. It's like a lot easier if you can like use it on an Excel document yourself. So anyway, we can try that later. But I appreciate there's probably some questions piled up. So. Or that.
Maybe have the slides that we do.
Yeah, and you'll have them, or Clara can make them available to everyone. Yeah. Let's start here.
Sure. First of all, thank you very much for the speech. I have two questions. One is that 30% refundable tax credit, does it apply to founders who are bootstrapping?
No, there's certain investors that are eligible for the tax credit. If you're the controlling shareholder of the company, you can't get a tax credit for investing in your own company. So no, that's not.
All right. And then my other question is regarding taxes. I realized that the company could owe money to the founder. Let's say I need to take $100,000 salary. I take $50,000 this year. And over the next 10 years, that accumulates to $500,000. What happens when I want to take that $500,000 as salary at the end of 10 years?
Okay, so a couple of things that go on there. So like, it depends on how you, so yeah, the question is like whether you actually like, you forwent some salary or not. So like if you had like $100,000 salary, like according to your employment agreement that you've drawn up with the company, and then you took only 50 of it, but then you went and you included in your like income tax, like that you only took 50,000 salary, right? Then there may not be more owing to you. So like I think if you want to like claim that there's like 100,000 that was to be paid to you, you'd have to include the whole $100,000 in your income, and then you have to say, well, instead of taking $50,000 of it, you actually took like yeah, exactly, like a note or something that says that you're owed 50,000. In which case, then you like do that every year. So you're paying tax on that extra funds, right? So at the end of like say 5 years, say a whole like 500,000 is built up, then you can just withdraw that as you would any other tax release. Yeah.
All right. Thank you.
And right next to you was another one.
Yeah, so generally, in your opinion, when would be the best time for startups to engage like a law firm to help out with stuff?
Yeah, I work with a lot of, I mean, the self-serving answer, obviously.
As soon as possible.
I think once you're sort of committed to this being sort of, you're gonna commit your full time and attention to this and grow it, that's usually the time at which you're probably going to incorporate. Certainly you're incorporating before you're taking on any investment. Likely you want to incorporate before you're contracting with any customers or suppliers and the like, but realistically, when you're gonna kind of decide this is what you're going to do. And I work with a lot of clients that incorporated themselves and then a few months later come and we kind of clean it up for them. That's usually fine, and usually there aren't sort of fatal issues. But it's not really efficient either. Like you've spent some money on some online platform to incorporate it, and you're just paying us to kind of fix it and do it again. So we do kind of price our services and have a sort of package offering, and other lawyers do as well, just to be clear, but so that it makes sense to do it right away with us as opposed to trying to do it yourself. And I'll say, maybe if you're sure you're bootstrapping and you're not really worried about bringing on investment, maybe it's less of a critical sort of time sensitive priority. But if you're bringing on investors, get your foundational structure set up in the right way so that they say, hey, these guys are working with Fasken. We know what their structure looks like. We're not worried about it. It does actually help. And again, I realize that's a self-serving comment, but it's true.
Okay, thank you. As a follow-up to that, say if I was budgeting for the next year, generally, like how much do you expect a startup to spend on legal costs for consultations or for any sort of?
Yeah, there's probably a bare minimum of get incorporated. You know, if you're a solo founder, it's going to be different than if you have multiple founders. It's good if you're bringing on investment right away versus maybe you're a year away from doing that. So, you know, the bare bones minimum is probably, you're probably going to spend a few $1,000s, and you can sort of work with whoever your legal counsel is to figure out a structure for that works for you. But the variation comes a lot from, are you in a regulated business, and do you need a ton of sort of regulatory advice right out of the gate? Maybe that's in privacy, or you're in, you know, a medical device or something like that. Things can get a lot more expensive. Do you need patents? Do you need other IP protection? So when I say the bare bones minimum, it's like your corporate structure, foundational documents, founder agreements, getting investor ready. That's the basic. If you're a solo founder, it's even simpler and maybe cheaper. But then, you know, what legal needs you have in the first year can balloon up quickly if you're in a regulated business.
Thanks. Yeah.
I have a question online.
Oh, go for it.
Related to the softball for a lawyer. So
Nice.
when using templates and written contracts, do these always have to be viewed by your lawyer before entering an agreement? The example is a Y Combinator safe template versus a custom safe.
Yeah, I mean, well, speaking to the specific sort of safe example, Y Combinator publishes a Canadian version of the safe, and it's not bad. Like we, you know, but like we have our version largely based on that. I think other firms in Canada will as well, and generally don't sort of like charge much to use it, but can walk you through sort of how to execute on a safe, the securities laws issues that you're going to run into that Sam walked you through. Other issues like that, it's not just taking a template and signing it and hoping that you're okay. There's a little bit more to it. But to answer the broader question, so can you just use templates? Like it depends what the template is. Like we'll provide a template employment agreement, and usually you can use that for most of your hires for quite a while, and it's got some customization in it. You know, downloading a template sort of service agreement for your customers, you're probably going to have some issues there that may be hard to fix later. So it really depends what the template is for. How critical is this contractual arrangement, and if it's important, get a lawyer to look at it. But again, contracting with your customers, like you can work with your counsel to develop a template customer agreement, SaaS subscription agreement, or services agreement, or license agreement, depending on what you're doing. Roll that out over and over again. You don't necessarily need to get them to look at it every time, but contracting with big enterprise, government, they're all going to have a lot of changes that you probably want your lawyer to look at. So yeah, templates are great. There's template, you can use templates for a lot of different things, but not everything.
We see it all the time in M&A transactions where you start looking at the agreements and we ask them what's in it and they just don't know.
Yeah.
You know, you'll just sign whatever's put in front of you, and you know, it kind of is what it is. But we would always suggest that you at least have someone look at it and protect your interests. Again, depending on how material it is, right? Yeah.
To a lawyer first.
Knowing what's material is like pretty important.
Yeah. If it's important, then you probably should. I mean, I mean, I click stuff on the internet all the time saying I've read it and I haven't read it, right? So, you know,
You're like buying pens for your office, like, and there's a contract purchase order, like, don't get your lawyer to look at that, you know, it's just kind of a judgment. Yeah, go ahead.
Hey, Geoff, a question more on risk management, right? So in one of your slides, you mentioned that directors and officers can be held liable for unpaid taxes and unpaid wages. So there are instances when if you're a startup, you know, you're strapped for cash, right? You've already issued out ESOPs to your employee. Let's say you mentioned to your employees, you say, okay, we can't make payroll this month, can you defer it? But then you actually don't end up fundraising and you file for CCAA or restructuring. And how common is it for early stage startups to have like D&O insurance to cover those accrued liabilities, for example?
Yeah. You're probably going to get D&O insurance when you get an outside director on your board, so an investor nominee or an independent. Often before that, it's not economical, and often providers won't even sort of offer D&O insurance. D&O insurance won't cover unpaid wages, unpaid taxes. You're kind of choosing not to pay those things. You can't really insure against that. So the tax aspect of it, a lot of companies that we work with aren't paying tax, like there's not generating profits such that they're paying taxes. And so unless they're withholding and not remitting or something like that, usually the tax liability isn't so much of an issue, but unpaid wages is important. So if you have employees, you're running out of cash, don't just assume you can kind of stop paying them and everything's going to be okay. That's usually where the issue arises. If you get into sort of a formal bankruptcy process, there's bankruptcy laws around dealing with unpaid wages and priorities, and hopefully at the end of the day, all your staff can get paid. But certainly, it's a more than a handful of circumstances where clients have had, directors have had to pony up some cash for unpaid wages because they just stretched it a little too long.
I'm gonna alternate.
Sorry, I'm like dog.
Sorry, this is another online question. For incorporations, does one need to incorporate both federally and provincially in BC? So, is there a need or benefit to incorporate both?
You wouldn't incorporate in both. You either incorporate in BC or Canada. If you incorporate in Canada as a Canadian company, or if you incorporate in BC and you operate in other provinces, you can register in those provinces to do business. So if you were a federal company, you would just register to do business in BC. You have a head office here. Benefits. There's a lot of nuance in the different acts, but generally speaking, you're probably okay if you're in any of them. Again, I think BC was long regarded as the kind of the most investor friendly or company friendly, I should say. There were just a few specific provisions that were just beneficial in BC. And that's kind of starting to be in place. A lot of the federal act is becoming, there's having more and more regulations on it with, transparency registers and things like that. So, for example, the one thing in BC we used to have that the other provinces didn't have and federal didn't have is that we don't require any Canadian resident directors. Probably not an issue here, but for example, foreign companies, when they incorporate in Canada, they would often incorporate in BC because we don't have to have a Canadian resident director. So there's certain things like that BC has been traditionally a bit more company friendly, but I think those things are going away and it's a lot of nuance. So, the one of the benefits of incorporating in Canada in any of the provinces or federally is that people just recognize Canada as a fair jurisdiction, right? And so things like the laws on incorporation and the corporate acts, they'll just generally be fair, and just make sense. And we're a recognized country around the world as just being, having just laws, I guess.
Yeah, I'd say in BC, we're still mostly incorporating BC, like probably 9 out of 10 of the local companies that we work with are incorporated as a BC company. Or we work closely with our Toronto group. I'd say 9 out of 10 of the companies there are federal companies and extra provincially registered in Ontario. It's kind of, and I would say there's not a significant enough difference between the two to really kind of worry too much about which route to go. BC is I think it's pretty flexible and easy to work with. And it's maybe a few $100s less to incorporate than just do federal and provincial. So that's often enough to pick.
A couple of questions. First of all, just to make sure, the non-Canadian people can be a shareholder. So someone from US or Europe can be a shareholder in a company.
Yeah, Hardeep talked a bit about like you could lose your CCPC status.
Yeah,
If you have too many non-resident shareholders and there's those like thin cap rules and things like there's implications to it. There's no legal restriction against it.
And then for securities laws, it's where you're resident. So if you're selling shares to someone in Hong Kong, whatever, it's Hong Kong securities laws that apply. In addition to BC.
I was gonna say so when I was talking about that, just the idea of who is a non-resident, that you have to dig into what that means. So if you're a foreign national, so not Canadian citizen, not a Canadian permanent resident, you could still be Canadian tax resident. If it happens to be that you've spent a lot of time in Canada. So if you have enough ties to Canada outside of your nationality and whatnot, then you might still be Canadian tax resident. And for tax purposes, that's what we would care about.
Okay. So, one more question. Can you elaborate more on different share classes and why we want them? So based on my experience, we have Class A and Class B, but 100% share Class A, 100% Class B, how it works when we want to sell and buy new shares.
Yeah, there's the overriding desire to keep it simple. And so usually we'll have one class of common shares until you go do an institutional raise where you create and issue preferred shares. Sometimes companies will have a voting and non-voting class, but that often doesn't actually achieve the objective you're looking for because there's getting into a bit of the weeds, but the non-voting, there's circumstances in which non-voting shares do vote, and then you're inadvertently creating a veto for that group that you didn't intend to provide. So often it's easier to keep people within one group and deal with limiting voting rights contractually can help too. And then as Hardeep talked about, there's like tax benefits potentially to having different classes. If all your founder shares are issued at a fraction of a penny and someone's investing at like $5 a share, they might want to be in a separate class for that paid up capital issue. But I'd say that's not a common occurrence, especially if you're issuing, doing convertible securities and then preferred shares and the like. So you can have multiple classes of shares. Sometimes you're doing tax planning too. Like we work with some, repeat entrepreneurs, high net worth entrepreneurs that are setting up a new venture and want to spend the time and cost to work with tax advisors on a more complicated sort of family trust structure and have different share classes and things like that. But all that's to say, on average, a simple structure with one class of shares is going to work most of the time.
Okay, and imagine that I have 10% of Class A and 25% Class B. How about my dividend?
What was the last word you said?
So imagine that I have different share
Yeah.
percentage in different classes. How do we calculate the dividend?
Yeah, I mean, dividends are a good question. I'd say almost all of the clients I work with aren't paying dividends. Like any excess cash is reinvested into the business until a much, maybe at a much later stage, you're paying out dividends to investors, but it's not super common. So, but to answer your question, dividends can be declared, and it depends how you structure the shares.
And the share rights and.
Yeah. So it can require that you pay dividends on all classes of shares at the same time. You could have it so that you can pay dividends on one class and not another. Within a class, it's pro rata though. So if you're paying on your A and you have 10% of that, you're getting 10% of the dividend. Paying on the B and you're 25%, you're getting 25%. If it's both, it's going to be the blend of the two, I guess. But
And this is why it's easier not to have multiple classes, right? You don't have to think about that. Everyone's treated the same.
Yeah.
And where it gets tough is, you have a layer of share rights, and then you're adding on top and on top and on top, and they all have to work together. So it just gets much more complicated. It's easier just to have the single, but where it really comes in is as you raise more money, someone's willing to write you $1 million check, but they're going to ask for a bunch of share rights. Well, that's the time where you have to start negotiating, put it in. But until you have to do that, you try to avoid it.
So what happens if you're already incorporated and then you want to bring on a co-founder? They can't be on the incorporation docs.
yeah, I always say kind of figure out what the end result you want to achieve is, and then work with your counsel to get there, work backwards from where you're at. So maybe you've got a company, it's been around for a while, you own 100% of the shares, you want to bring on a co-founder and give them 25%. It's not complicated to do that. It's tax gets in the way, and so can work with someone.
And incentivization and things like that.
Like how do you get them the equity without it being employment income, for example, or
there's a tax, then there's how do you make it so that it's not you achieve the outcome that you want, like Geoff said. So for example, if you want this person to stick around for a certain number of years before they actually have those shares, then you may want to put in a vesting schedule and whatnot.
Because, to be clear, the reason you can sell or give out founder shares at a very cheap price to start is because your business isn't worth anything.
Yeah, there's nothing in it.
The problem is, 5 years down the road, you've actually built something. Maybe you've done in a couple of financing rounds, and okay, these things are worth 5 cents each. If you go back to giving them away for free, then you get run into the tax issue.
Yeah.
Yeah, so my question is, can you elaborate on advisory board share structure? What's the typical numbers that you give to advisory board?
Yeah, there's some there's some data online, but it depends on the stage that the company's at, and also to some extent what kind of help that they're providing. And actually, I've got this slide up here, like you'll see board of advisors, that's gonna be your smallest percentage of your option pool. And so, you're ranging from the like, 0.1 to 0.5%.
Like that's what I
Often,
heard.
but, is it day one, you've got an idea, you're thinking about incorporating and you've got somebody that you want them to help you out. Maybe you've got to give them a little bit more. Maybe your early commercialization and it's okay, we're on our way. Like we're not going to give away a ton of the company and we'll give you 0.1%. So for advisors, I'd say there's a good sort of industry standard range. When it comes to like new executive hires and the things like that, it's just all over the place. So it's really fact specific, depends on your circumstances.
Sounds good. Thank you.
I have worked with clients who in the early days kind of give away a bit too much equity to their advisors and regret it later, but
It seems free, right?
yeah, and I kind of try to sometimes talk them out of it. And anyway, try not to impose my business view too much, but it's a common error I come across.
Just have to be generally careful about who you give your shares to.
Yeah.
Because those people will have to like sign off on whether there's going to be an audit of the company or
You
not.
potentially have to deal with them forever.
Yeah,
You can't just take it back.
those are like important decisions.
Couple more, I guess, looking for them online. So someone's posted a link to FTC saying non-competes and non-solicitation
Yeah.
are considered unfair in the US. So how would that?
Not the case in Canada, yeah, but it was pretty interesting news kind of the US. It was kind of already the case in California for the most part. And so now it's just, I think, all across the US, I guess, but and it's not too different in Canada in the sense that we talked about, your rank and file employees, you can't impose a non-compete.
Unless you're the CEO of, a
It's-
TSX,
yeah,
large TSX listed company or something, and you're getting paid out a few million bucks when you're fired or something like that.
Yeah. It's your executive level kind of management where you're gonna have a non-compete. And even then, it's the court's gonna look to a very narrow range. They do get challenged and frequently challenged and infrequently upheld, but we'll see. I don't know if we're gonna see a blanket ruling like that in Canada, but they're still enforceable in Canada, but it's just this
Very
sort of
narrow.
very narrow. That being said, like, it doesn't, including a non-compete doesn't necessarily create problems on its own, and it can be a useful tool to discourage people from competing, even if you have,
Even in the end, if they went to
No.
court, they could.
yeah, even if it's not going to be upheld, it's kind of like, hey, you agreed to not compete, you can't do this, and there's some value in that, I suppose, but again, not just kind of your everyday employee, it's just probably not worth it. And it's not, and it could be, not a great HR policy.
So what is the best way to, in terms of tax, to get offshore employee? So because this is a cost for me.
Yeah.
I'm getting someone, I don't know how he or she will submit his tax within his own jurisdiction or from Europe or from any place in this planet.
Mhm.
But it's just cost for me. How can I file
The
it?
easiest way of doing it is to just have like that person be a contractor. So like if the person is like not located anywhere, like you have access to them anyways, then there's an argument to be made that you don't have much control over this person's activities, or at least less control. So like that, like using saying that relationship is a contractor relationship may be fine, at least from like a legal perspective. And then like they can file their taxes in accordance with whatever they need to do in order to like meet.
Even if they're individuals, they can have a contract, sure.
Yeah, they can be individuals that are contractors. They don't have to have companies themselves.
I think most for companies, most non-Canadian kind of team members, at least in the early days, are often hired as contractors at the risk that Hardeep was alluding to, that they're not properly characterized. As the company grows, maybe you're hiring more and more employees in the US, set up a US subsidiary as your employer down there. There's these organizations called employers of record, like Deal is one of them. And so there's like, they hire the employees, you contract with them, and those are all over the world. I'm seeing that more and more too.
Yeah, I've seen that quite a bit.
Yeah.
There are some tax issues there too, but
Yes, yeah.
you just like, there are ways around it. Like you just look at it more as you have like more of an issue.
Yeah.
Like, yeah.
Cut there, but we can also grab for a few minutes afterwards. What were your optional slides? Just.
Oh, it's like, hey, here's cap table evolution, you know, you've got your founder shares, bring on some friends and family investors at 25 cents. How much do you own now? You're getting diluted down. Angel investors, you've got a stock option pool now too. Just to show you kind of how the dilution works. You'll always have your 6 million founder shares, but you're issuing more and more shares from the treasury, and you still have, you know, they're hopefully worth more on a per share basis, but you're diluted in a lower percentage of the overall picture. Oops, that jumped ahead a few. Oh, hey, there's me, I think 8 years ago. And yeah, so as you do more rounds, you're probably diluting maybe 20% each time, and you know, your position gets diluted, but you know, you're increasing your stock option pool. So again, it's hard to really like follow this in a slide format I've found, but it's there anyway. Have a look at it when you get the hard copy slides. There's us.
Well, thank you again. I think we're gonna wrap it there, but I think Sam, Geoff, and Hardeep can stick around for a few minutes if you want to ask any questions. Thanks for everyone watching online, and we'll see you next time. Have a good day.
Thank you.
Thanks, Angie.
Thank you.